Gavel raised, the judge prepared to close the case exactly as everyone in that Cedar County, Iowa courtroom expected. The foreclosure on the Kowalski property is finalized. This court is adjourned. Daniel Kowalski, 47 years old, stood at the defendant's table without a single visible reaction. "Your Honor," he said evenly, "before you close the record, I'd like one specific document entered as an exhibit." The judge paused, clearly unaccustomed to a defeated party making requests. Bank attorney Richard Voss glanced at his colleague, unbothered, assuming this was simply a formality before the inevitable. Daniel wasn't finished yet, and within the hour, that same unbothered courtroom would fall completely silent. "Before we continue, tell me in the comments, what state are you watching from tonight?" Grain dust still clung to Daniel's boots that morning, evidence of the harvest he'd been running just hours before driving to court. His grandfather had started the operation on 300 acres back in the 1960s, and over 2 decades of careful expansion, Daniel had grown it into 1,200 acres of some of the most productive corn and soybean ground in Cedar County. Trouble arrived 3 years earlier when commodity prices crashed hard, cutting Daniel's revenue nearly in half in a single season. Heartland Agricultural Bank had held his operating loan for over a decade without incident. But that year, a new regional manager quietly reclassified Daniel's loan from a standard agricultural line of credit into a different lending category, one with steeper collateral requirements and accelerated default triggers. Nobody explained the change clearly. Daniel remembered receiving a letter mentioning updated terms buried in dense paragraphs he'd skimmed during planting season, assuming it was routine paperwork like every other year. By the time yields recovered the following season, the bank claimed he'd already triggered default under the new terms. Terms Daniel didn't fully realize applied to him until foreclosure proceedings began. Fellow farmers in the area urged him to fight loudly, to bring the story to local news outlets, to make noise the bank couldn't ignore. Daniel listened politely and pursued something entirely different instead. Every evening after finishing chores, he sat at his kitchen table, cross-referencing old loan statements, correspondence, and the specific date that reclassification letter had arrived. His wife Carol, watching him work through the same documents night after night without raising his voice once, finally asked what exactly he was hoping to find. "I don't know yet," Daniel admitted. "But something about that letter never sat right with me, and I want to understand why before I decide what to do." Weeks passed with the bank moving forward confidently, scheduling equipment and land for auction as though the outcome were already settled. Auction notices went up along the county roads, and Voss's office sent a final letter suggesting Daniel make arrangements for vacating the property ahead of the scheduled sale date. Confidence radiated from every communication the bank sent, each one treating the case as fully resolved. If you've made it this far, you already sense Daniel isn't finished. And if you want to see exactly what leaves this courtroom speechless, hit subscribe now, because we're getting close to the moment everything turns. A neighbor mentioned a retired bank auditor named Frank Delgado, who'd spent 30 years reviewing agricultural loans before retiring from a competing bank 2 counties over. Daniel drove out to meet him, bringing his folder of statements and the reclassification letter that had bothered him for weeks. Delgado read through everything carefully, his expression shifting somewhere around the 3rd page. "This reclassification," he said, tapping the letter, "moved you from an agricultural production loan into a commercial default category. That's not a minor administrative change. That's a completely different regulatory framework, and banks are required to disclose that kind of shift clearly, in writing, with borrower acknowledgement." Daniel felt something tighten in his chest. "I never acknowledged anything like that." Delgado looked up. "Then I'd say your bank may have a serious disclosure problem on their hands." Back in the Cedar County courtroom, 2 weeks later, Daniel's attorney, a sharp young lawyer named Priya Anand, stood before the judge holding 2 documents. "Your Honor, I'd like to draw the court's attention to a critical disclosure failure. Heartland Agricultural Bank reclassified my client's loan from an agricultural production line of credit to a commercial lending category in 2023, a change that carries significantly different default triggers and collateral requirements." Voss straightened in his chair. That reclassification was communicated through standard correspondence, entirely within normal bank procedure. "Standard correspondence isn't sufficient under state agricultural lending law," Priya continued, unbothered. A reclassification of this magnitude requires explicit written acknowledgement from the borrower, confirming they understood and accepted the new terms. My client never signed any such acknowledgement because none was ever provided. Silence spread through the gallery as the judge examined the original letter, then the loan file the bank had submitted as evidence. Nowhere in the paperwork was the required acknowledgement form Priya had described, because it had never existed. Your Honor, Priya said, if this reclassification wasn't properly disclosed and acknowledged, then my client's account was never legally in default under the terms the bank now claims. The entire foreclosure proceeding is built on a classification that was never valid to begin with. Voss began flipping frantically through his own copy of the file, searching for a document that clearly wasn't there. The judge removed his glasses slowly, looking first at the empty space in the file where an acknowledgement form should have been, then at Voss, then finally at Daniel. Nobody in that room moved for nearly a full minute. This court, the judge finally said, his tone entirely different from the one he'd used to open proceedings, will not uphold a foreclosure premised on a loan classification that appears to have been improperly disclosed. I am vacating this ruling and ordering a full review of the reclassification process before any further action proceeds. Voss said nothing. There was nothing left in that file to argue with. Word of the reversed ruling spread through Cedar County within days, catching local farmers who'd assumed the case was long settled off guard. Heartland Agricultural Bank's compliance department confirmed, 3 weeks later, exactly what Delgado had suspected. The 2023 reclassification had bypassed required borrower disclosure procedures, not just for Daniel, but for at least 5 other agricultural accounts flagged during the resulting internal review. Daniel's loan was restored to its original agricultural classification, and the foreclosure was permanently dismissed. That wasn't where the consequences ended, though. The state's Agricultural Lending Board opened a formal inquiry into Heartland's reclassification practices, prompted directly by the documentation Priya had submitted during the hearing. A neighboring farmer named Roy Estep, who'd received a similar reclassification letter 2 years earlier and simply assumed it was routine, called Daniel once news of the ruling spread. I threw that letter in a drawer and never thought twice about it, Roy admitted. Didn't know it mattered until now. Steady pride settled into Daniel's routine over the following months, though he rarely discussed the case unless someone brought it up directly. He kept farming the same 1,200 acres his grandfather had started with 300, land he'd very nearly lost to a paperwork change nobody had bothered to explain properly. Carol asked him once why he hadn't just gone to the news the way everyone suggested. Daniel thought about it while checking the grain bins one evening. Noise gets attention, he said, but proof gets your farm back. I needed the second one. Sometimes the strongest move isn't a loud fight. It's quiet preparation that speaks for itself when it matters most. Daniel never raised his voice once, and it saved everything his grandfather built. If stories like this move you, subscribe, because there's more coming every week.